I'd like to bring my associate up, who's joining us from I believe our Long Island office today. He's in the New York City office most of the time, and that is Anthony Khatchoui. And Anthony works with me focusing on creating plans for high net worth individuals, high net worth families. We're going to talk about some of that planning next. He has expertise in gift, estate, and generation skipping transfer tax planning. He's recognized as one of the best lawyers in America in 2026, upcoming, and for the last 3 years. He is a JD cum laude from Boston University School of Law. And with that, I introduce Anthony Khatchoui.
Nice to meet everyone. Apologize for letting everyone down. The previous speaker, who was remote, was from an exotic location like Hawaii. Sadly, I'm only in Garden City.
But nonetheless, you're here. So this is our firm, and the attorneys, I introduced some of them that are here today. We have our offices here, main office here in Latham, another office down in New York City. And when we sit with clients of all means, all ages. We do a lot of elder law, we do a lot of special needs planning, but we also focus on a high net worth marketplace. And there are common goals, common threads among our clients as to what they want to accomplish, what do they want to build into their plan so that they can succeed, and they can succeed for themselves, their spouse, their families, and create legacy. So we want to have control over wealth. And the plans we're going to talk about today are geared to maintain control. Health, if you don't have it, the money doesn't help you. So we want to make sure that we have a health plan, that we have enough in our plan to maintain good health, and that's the spectrum of wealth. Health is one of the key components in making sure we have the right planning. Financial security, taxes we're going to talk about very much today. Income tax, capital gains tax, estate and gift tax, generation skipping transfer tax, and I could go on and on. Their Beatles song, "If you want to walk, we'll tax your feet." Anybody old enough to remember that song? Because I'm the tax man. One person. All right. Look it up. Look it up on YouTube. The Beatles, the tax man. Protection from risks, creditors, predators, disability, long-term care, and are we going to take care of the charities? I know a lot of people right now donating money to food banks and looking at charities that are part of their planning because of the current economic situation and the government shutdown. So working that together with your clients, finding the best ways, the most tax-advantaged ways to give, and then for our children and our grandchildren, education. So important and so misunderstood in many places today, but we want to make sure that they're getting the best education possible. Financial security, immaturity protection, what we call a spendthrift trust, for children who just can't handle money. All of these are considerations. Divorce protection, one of the big ones that our clients have. When we ask them, what risks do you worry about for your children? The in-laws. I worry about my son-in-law, my daughter-in-law. What's going to happen when I leave my child wealth from our family? Is it going to be protected? Is it going to be lost in a divorce suit? Other lawsuits and protecting assets, and then, of course, tax planning. Just a quick note. Be sure when you're talking to your clients about planning that you cover the basics. You button up the fundamentals. Make sure they have a power of attorney that's well thought out, well drafted, and coordinates with the rest of their estate plan. Make sure that you have a healthcare document, a healthcare proxy and living will. In our office, they're a combined document. You never want to see your clients have to go to court and go through a guardianship hearing. We do a lot of guardianship work in our firm. It is not the most pleasant thing to do. You have your family laundry aired out in a courtroom, and burdens of proof and evidence that have to come in to say mom or dad is incapacitated, and then who is going to be the guardian, who's going to take over their finances. A good plan with a good power of attorney, healthcare proxy, is a good start. And now let's turn to taxes. And this is something that a lot of people don't understand, and for good reason, because New York has cobbed together one of the most Byzantine and punitive tax systems for estate and gift tax. So in New York, we have an exemption of $7,160,000. I mentioned earlier the upcoming federal exemption of $15 million. That's federal. New York is $7,160,000. We had a great talk last night at the dinner table among all the speakers, and it was, what was the exemption, the federal exemption, when you started your practice? And I think Elwin had the prize with 100,000, 50,000, $60,000 was the exemption when he started. It was 300 when I started. The New York State exemption was $108,333. That was what you got to pass on tax-free in New York in 1984. And so today we have 7.16 million. Seems like a lot of money until you realize that's life insurance, retirement accounts, real estate, and you bundle everything together. Is the client at risk for facing a New York State estate tax? And if they haven't planned for it, there is something called the cliff, and you don't want to be on that cliff, because if you get over the 7.16 million by just 5%, and this graduates up from 100% to 105%. If you get to 105% of the tax exemption, your entire exemption is gone. So you pay tax not on the incremental amount, but on $1 in your estate, all the way up to $7.518 million, which goes from zero to $740,000 in tax. So planning for clients that are facing this, that are starting to accumulate assets over time, that are getting close to the cliff, starting the planning at that point in time is critical. And we can use deductions. Say again, Anthony?
Just want to point out to the crowd that if you see that there's only a delta of around $358,000, but the tax will result in $740,000. So you have scenario one, person has $7.16 million, zero tax. Scenario two, person has $7.518 million, just $358,000 more, $740,000. So the tax is over 100% of the assets. It's punitive.
So when you're building a plan, you want to make sure you're taking advantage of deductions. If it's a married couple, we're going to talk about that next, the marital deduction. If it's not, a charitable deduction can be built in on top of that trust and be there so that a charity can get money rather than the government, and it will maximize, ultimately, we do a formula, ultimately the inheritance to the children. So all of this planning just for that New York State estate tax, forgetting even about the federal estate tax. The other rule in New York that you have to know is that we have an unlimited or no gift tax. So you can gift $1 billion in New York and pay zero tax, with one caveat. You have to survive 3 years. There is a 3-year clawback. So for clients that have the ability to gift and drive their estates down below 7.16 million, provided they do it soon enough and last 3 years, all of that money escapes New York State estate tax, and the top rate in New York is 16%. The top rate federally is 40%. So, Anthony, we have trust planning for married couples where that marital deduction plays an important role.
Absolutely. So when you're doing New York State estate tax planning, you're going to want to have separate trusts that are built into your revocable trust document. So clients will often think that they have a revocable trust. It's just one trust, but there's actually multiple trusts for different portions of your life and your loved ones. So you need to have a trust, a family trust, that will utilize the grantor's New York State estate tax exemption. So there's something called the marital deduction. And what that means is if you make a transfer during lifetime or upon death, there is no exemption used. And many clients think that's a positive thing. Wow, that's wonderful. I can give as much money as I want to my spouse during lifetime or upon death. There's no tax. But what they don't realize is that all that does is simply move those assets over to the ledger of their surviving spouse. And if you don't have this family trust to soak up your New York State estate tax exemption, the assets are in the surviving spouse's estate, and then upon their death, they are now over the cliff. So a simple example would be if a husband and wife had $10 million, and let's say it's going to go to the surviving spouse. So let's say in this scenario, they each have $5 million of assets. The husband is deceased. All the assets go to the surviving spouse. What happens now when the wife dies? She has $10 million. She exceeded the exemption. She's over the cliff, like Lou said. And the unfortunate thing in this scenario, Lou, is that many clients will hear of the federal estate tax exemption and say, it's 15 million. I'm not going to have estate tax, not realizing that there's a dichotomy between the New York State estate tax exemption and the federal exemption. So to avoid that from happening, we need to build into the trust a family trust, a way to soak up and utilize that New York State estate tax exemption and have a trust that's for the benefit of the spouse and your family up to that $7.16 million. And then anything in excess of that is put into a marital trust with the idea of that those assets will now be deferred into the surviving spouse's estate. So for example, if someone had If the husband had $9 million and he's deceased, $7.16 million is going to go into the family trust, and that excess, that $1.84 million, is going to be taxed in the surviving spouse's estate, that $1.84 million. And by doing that, you could hopefully avoid New York State estate tax.
So there are a variety of mechanisms to finance the funding of the family trust and the funding of the marital disposition. And we listed a few of them: Clayton Q-tip elections, formula clauses, disclaimers, all things that we do as attorneys to build in this tax planning. But this way we can double the exemption and allow for $14.32 million to pass tax-free for that married couple. Funding the trust is critical. We do it in 2 trusts to make sure we can maintain that balance throughout their lifetimes so that we know exactly how much is going to be available for the exemptions. And so this is planning at a base level for New York State estate tax. You don't have to worry about the federal estate tax at this level, but there is one more tax that we are going to mention, and that's generation skipping transfer tax, which is when you create a trust that's going to bypass the children or be in trust for the children, but ultimately go to grandchildren and beyond. There is a second tier of tax at 40% on top of the estate and gift tax of 40%. So the GST tax is something that becomes punitive if you don't plan right for it. And here we can make gifts. We can gift more than 3 years prior to death. We can move assets out. And for New York State purposes, no gift or GST tax. And we can allocate our federal gift and GST exemptions to those transfers. We're going to see how that plays out in a trust in just a moment. So,
and Lou, if I may,
go ahead, Anthony.
It's important that the clients, when they create these trusts, that they fund their trust. Because if you don't have assets to utilize the exemption, then you haven't achieved your purpose. So if you have a revocable trust and you have the family trust and the marital trust, and you have all these fancy trusts to utilize your exemption, but all the assets are in the husband's name, and let's say the wife is deceased first, she has squandered the opportunity to utilize her exemption because she doesn't have the assets. So you could have a Lamborghini of trust, but you need to have fuel in it. You need to have assets. So clients often will have great trust documents, great estate planning documents, but you have to dot the I's and cross the T's. You have to actually transfer those assets into the trust, balance the assets. Like Lou was saying, clients often don't realize that even retirement assets are part of their taxable estate. Life insurance, there's always the misnomer that it's not taxable, but that's only for income tax purposes. So the trusts are great, but you have to also focus on the funding as well.
You mentioned retirement plan assets. That's the hardest asset to weave into the estate plan because they're not owned by the trust. They're not subject to the formula clauses. There's going to be a designated beneficiary on the IRA, 401k, 403b, and it's going to go to that individual, or you can name a trust as the beneficiary. So the Secure Act came to us, and then Secure 2.0, and we have final regulations, which just came out last year. And I think next year we're going to do more of a deep dive into IRA planning because this is really the main asset for many of our clients. They come in the door, they have a house, they have IRAs, retirement accounts, and some investments, but it's become the central asset for most of our clients. So when we look at it from that perspective, there's income tax on every dollar of that. Children have a 10-year payout period under the Secure Act. You have eligible designated beneficiaries that can stretch it over a lifetime. And we're going to try to create a trust and thread the needle to get that retirement account into a trust to maximize the benefits. Marital deduction planning, Anthony, isn't easy because the ideal solution for a retirement account is a spousal rollover in a marriage where you want the spouse to have full control and access. But that may not be the ultimate result if you need to use that for the credit shelter to get into that family trust.
Absolutely. We recommend having the spouse as the initial beneficiary, but as a contingency to have a disclaimer so that way she could disclaim and utilize that family trust.
He or she can disclaim.
He or she, that's right. So that way you could utilize the exemption of the deceased spouse.
So you have to weave all the assets together into even just a revocable trust plan at this level. Let's turn to federal tax. 15 million we talked about this year. Right now, today, it's 13.99 million. That's the federal exemption for gift, estate, and generation skipping transfer tax. You can use that during lifetime. If you do, it absorbs your estate tax at death. You can gift $19,000 per person per year. A married couple can double that to $38,000, either by gifting separately from a joint checking account or by splitting the gift on a gift tax return if only one spouse owns the asset. So gifting programs and annual gifting programs are very, very powerful. We can pack beneficiaries into the trust and give them demand rights over a trust. We've had 20 beneficiaries on the trust, so you can make 20 annual exclusion gifts, even though it only passes to the 3 children at the first instance. So you can use a series of beneficiaries and contingent beneficiaries to shelter annual exclusion gifts, and then have it go to your primary beneficiaries in trust, and we can allocate GST exemption, and that's going to be a trust that's going to last for a long period of time.
And Lou, that's a pretty powerful thing. Just want to emphasize that the $19,000, if you have 10 beneficiaries, that's $190,000 every year that you could use without using your exemption. And over time, that's going to compound and be a significant amount of savings that you could give to your family.
Absolutely. And that applies to both state and federal, by the way. Married couple can transfer $30 million, and there's portability in an estate for federal tax purposes. What does that mean, portability? That means when one spouse dies, you can file a federal estate tax return to 706, check a box, make an election, and allocate or port that spouse's exemption over to the surviving spouse. So now you can have that exemption, even though you've done no planning for federal taxes in the first estate, you can have that exemption poured over, so you get a $30 million exemption in the second estate. Be careful, though, because in most of those high net worth plans, you're creating trusts which may have grandchildren and great-grandchildren as beneficiaries ultimately, and there is no portability for the generation skipping transfer tax. So you still want to do the credit shelter planning, even though there's portability federally for GST purposes. So the marital plan that we rolled out, the revocable trust, 2 trusts, having a marital trust, a family trust, it applies for state, it applies for federal, and you need it federally primarily for the GST tax. I'm going to let Gretchen sort this slide out. These are all the income taxes that our clients face. We deal more with capital gains taxes and step up in basis and trying to create step up at death for highly appreciated assets. That's part of a trust plan. But look at the rates here. If you're in New York City, God help you, you're paying 55.3% on things that are coming in with net investment income tax, a New York City tax, the New York State maximum rate, and the federal maximum rate. That's where we are. Even capital gains without the New York City tax is about 35% if it's net investment income. So these are high rates. We have to be cognizant of these in our planning. And when we start looking at transfers, we're going to transfer to trusts. We're going to be doing gifting. We're going to be doing some sales of assets. And certain trusts are premised upon interest rates. This is the list of trusts that have interest rate volatility as part of their core. And when we do grantor retained annuity trusts or charitable lead annuity trusts, we had these trusts on sale for a period of time. I'm going to show you why. Now we're up to more high rates, qualified personal residence trust, grantor retained income, charitable remainder annuity trusts. Look at the rate chart, 20 years. We've been here 20 years, right? So we've been talking about this. In 2005, we had a 4.04 short-term rate and a 4.57 long-term rate, kind of normal rates. You go to 2020, we had a 0.13 short-term interest rate and a 1.17 long-term interest rate in 2020. So you could sell assets within a family for a 30-year note at 1.17% and move all the appreciation of those assets downstream. The volatility in these interest rates over the last 20 years is dramatic. And what was on sale during those years of 2012, 2011, 2020, were all of those interest rate sensitive trusts on the left favoring the lower rates. We're back up now to 3.69. It's going down a little bit again. The high water mark was 2023 at 5.3% for short term. And look, it's inverted, 4.83 long term, 5.3% short term interest rates. This is a very important chart for your clients because when we look at creating trusts and trust planning, we're going to be doing gifting, we're going to be doing trusts, we're going to be doing trusts like personal residence trusts, which we're doing more of now, charitable remainder annuity trusts we're doing more of now. It all hinges on that interest rate. So you want to be cognizant of that as you're recommending techniques, that those low interest rate techniques were better 5 years ago. The higher interest rate techniques have come back and are more in favor again today. So we're going to turn now to two trusts for the remaining, we got about 20 minutes, I think. And these are two of our key trusts, the Spousal Lifetime Access Trust and the Beneficiary Defective Inheritors Trust. And the reason we like these trusts are they work in any environment. They work in a low interest rate environment. They work in a high interest rate environment. They work with volatility, and it allows us to do things in a way that does a lot of good without really doing any harm. So where to form the trust? We like anywhere but New York, because New York's laws are the most antiquated in the country. We have a trust statute that's been around for about 100 years. And we have a law professor, my professor Ira Bloom from Albany Law School, wrote a new trust statute for New York about 10 years ago. And it's been sitting about a block up from here on the legislators' desks for the last 10 years and has gotten absolutely no attention or play. So we're stuck with very antiquated rules in New York. So we go to Delaware. We go to Nevada. Now New Hampshire is a new player in the game. And some local banks have staked out territory in New Hampshire because they have trusts that can last in perpetuity. They don't have to end. They're fully directed, meaning you can have a trustee but still retain family control of that trust. No fiduciary income tax, no state income tax. A court in Delaware of Chancery, which is trust and estates lawyers governing trust and estates cases, and other statutory provisions. The basic structure here, you have an administrative trustee at the core. All they're doing is bookwork and administration. They're facilitating the trust. They're not investing money. They're not making determinations of distributions. You can have other distribution advisors do that. They're not managing any of the investments. And so this is a very flexible structure for family control. And I'm going to go right to here, Anthony, because let's see if we can get the flow chart. It's big on that screen, smaller on that screen because we have you there. But just walk us through this. When we do this, and what made me do this presentation this way is we present like this to clients. Anthony's in New York City, I'm up here, and we're giving the clients an explanation of their plan. So with that, Anthony.
Sure. So you'll see at the top, each client will have their own revocable trust. And typically the client and their spouse, they're going to be the grantor, the creator, the trustee, the one that's in charge of legal title of the assets that will make investments and distributions, and they're the beneficiary. And the revocable living trust is the mechanism that will hold your lifestyle assets, cash, probably your primary residence, things that you want to have immediate access to. You could amend it, restate it, revoke it. That's where we're going to also have the family trust and the marital trust to try to defer estate tax upon the death of the surviving spouse. So you have the revocable trust there, which is just basically yourself. You take money in, you take money out, you can amend, restate it, revoke it. If you look below it, you'll see the holding company. The holding company is where we like to put assets in that will ultimately be gifted to the dynasty trust. So to utilize the exemption that Lou is referring to, the $15 million next year, you have to make a gift. You have to part with the dominion and control, the beneficial enjoyment of that property. You could do it outright, and then you'll probably never hear from those family members again because they'll be traveling the world and they'll forget all about you. Or you could put it into a trust. You could put it directly into the trust, or you could put it into the LLC. And we like the LLC because the client can be the operation manager, the one who's in control of the day-to-day operations of the LLC and investments of the LLC. And what we do is we put the assets in that LLC, and then the client will sign a piece of paper that gifts it to the dynasty trust. And the dynasty trust, those are spousal lifetime access trusts for the benefit of the spouse and descendants. I don't know if you could see the flow chart in detail, but you'll notice that each Delaware trust or dynasty trust has different provisions. The purpose of this is to try to defeat the reciprocal trust doctrine, which is what the IRS will try to use to bring these assets back into clients' taxable estates. So you'll notice that the lifetime beneficiaries on the John Doe trust are the spouse and descendants, but on the Jane Doe, it's the spouse and children. The investment advisor will typically be different. We'll have the client, John Doe, be the investment advisor of his trust. Jane will be the investment advisor of her trust. So we'll have different advisors, different provisions in the trust. We may have the ability to add a charitable beneficiary to one trust and not the other. One spouse may have a limited power of appointment, the ability to appoint the remaining assets in the trust to descendants, while the other spouse will not. We'll have different assets in the trust. We'll sign the documents at different times. So we're trying to layer in differences among the trust, but ultimately, these are trusts where they're for the benefit of the entire family. So in this scenario, if you put $15 million into the LLC for the John Doe holdings, $15 million into Jane Doe, they make this gift next year or in 26 and 27 to separate the years, they will fully utilize their federal estate tax exemption. They'll also apply their GST exemption to it. So the assets could then grow in perpetuity outside of their taxable estates, with all appreciation also out of their estates, and it could be gifted to, distributions could be made to grandchildren with no additional tax. So think about it. They're going to make this gift in 26 or 27. These assets will continue to appreciate because they'll have Cerity or other financial advisors growing these assets for them. And all that growth is outside of the taxable estate. So for years, when it was the Tax Cuts and Jobs Act, estate planning practitioners were harping on clients to utilize their exemption because there was the impending sunset. January 1, 2026, the exemption was going to be cut in half. Now, clients are sort of lulled into a little false sense of security because they'll say, well, there's no more sunset. The One Big Beautiful Bill Act passed. My exemption is permanent. What do I have to make this transfer for? I have the exemption. But the problem is that while the assets are in your name, when you don't implement this structure, the assets are growing in your estate. So if you do something like the rule of 72 and you say that my assets are going to grow by 8%, so that means that every 9 years, your assets are going to double. So the longer you wait, these assets are growing in your name, in your estate, and could potentially result in estate tax issues in the future. So you put the assets in the LLC, the client's the operations manager, controls the day-to-day operations, investments, then they're going to gift that LLC to their dynasty trust. Sometimes clients will be so fortunate, so successful that their assets exceed $15 million. What do? Do we pay tax? Never. We never surrender. We always try to find another way. So what you could do in that scenario is you could implement a little bit of a, thank you. You could implement a little tweak to the structure, which is by bifurcating the LLC membership interest. You could have voting and non-voting shares. And the non-voting shares are going to make up the overwhelming majority of the LLC membership interest. So, for example, the LLC will have 100 membership interest. 2 of them will be voting interest. 98 will be non-voting. And the non-voting membership interest won't have the ability to vote for the managers, won't be able to control distributions. And because of that, if you get a third-party valuation company to come in and look at the operating agreement and say, what is the value of these non-voting membership interests? Could I get a dollar for dollar value? Can I get 100 cents on the dollar? The answer is going to be no. Because if I went to someone on the street and said, here, there's $10 million in this LLC, I want to sell you 98% of it, so I want 9.8 million. But the catch is that you can't control who the managers are or distributions. And by the way, this is a private asset. It's not on an exchange. It's not on a market. I can't readily transfer it into cash. Do you want to pay me 9.8 million? The person's going to say no. There's restrictions. I could just have $9.8 million of Apple stock, something that I could easily convert into money. Why would I want to pay dollar for these assets? So we build the LLC to have these special provisions for discounts for lack of control and lack of marketability. And by doing so, a valuation company will come in and say, even though this LLC has $10 million worth of assets, we're then apply a discount because a willing buyer and a willing seller, the willing buyer would not pay full value for those assets.
So you mentioned the risks. I can tell you from our clients that when they come in and they're reviewing their plan, they only bring one document. They have 200 pages of trust documents and LLC documents. They bring their flow chart. And they have notes on the flow chart, and they're following the plan on the flow chart. And it is critical to them because the visual representation of this plan is what really makes it resonate. And when we look at the risks, we can overcome those with good drafting and good execution. The results are all of those client goals: retained use and access to assets, retained control over assets, asset protection. These trusts in Delaware are fully asset protected for both parties: husband, beneficiary of wife's trust, wife, beneficiary of husband's trust, along with the children and ultimately the grandchildren. They can even have a power to change beneficiaries ultimately on that trust. We don't have any estate tax. The GST tax has been locked down. We've escaped $30 million of New York State estate tax as well with this plan, and all the future growth is going to the next generation. The heart of this, and you're going to hear from Nathan at Empire Valuation in just a bit after the coffee break, the heart of this is control through the LLC and the discounting on the valuation. We have a client we did this plan for about 15 years ago, and he got a very aggressive valuation of his company. It was an operating business. And then we did a discount further for lack of control and marketability of his limited liability company. And we were able to move the entire company out of their estates. They did spousal lifetime access trusts. He sold the company 4 months ago for $312 million. Every penny of that is in a trust, both estate, gift, and generation skipping transfer tax free. That's the appreciation, that's the effect of doing this plan at the point in time when those assets have not yet ballooned or mushroomed. So the LLC creates that discount. 98% has no control. So we can layer in those discounts. You'll hear more about that in a bit. I want to jump forward for the last 5 minutes to the second type of trust that I wanted to discuss today. And this one is a little more esoteric. Far few people, if you go to your AI tool, whatever you use, I use Perplexity, a tool that I like very much. But if you go and you put in SLAT, just S-L-A-T, you'll get 1 million hits. If you put in Beat It, you get a lot less, because not that many people know about this trust or have utilized this trust. And I don't know of a lot of practitioners locally that have used it, but we're using it for our clients very actively. And this is a trust that allows an individual to have their assets go into a trust that they can be the trustee of, they can be the beneficiary of, they can manage the investments in, it can be a grantor trust for income tax purposes, and yet all of the growth in that trust is outside of their estate. And we get discounts on the way in using a limited liability company, so the value can be crushed down and then balloon out when the time comes. So the Beat It is a trust where we have someone other than the client, dad, mom, brother, sister, somebody, friend, who has $5,000 that they will put into a trust for this individual and create the trust and sign the trust. They're the nominal grantor of the trust. And you give the person, the primary beneficiary, the right to demand that $5,000. Under 678 of the tax code, that creates a grantor trust for income tax purposes as to the beneficiary. Not the person creating the trust, but the beneficiary. That's what makes this trust so special. So now that individual who is the beneficiary, who owns a business or has a large portfolio of marketable securities, can sell their assets into the trust. And Anthony, we have about 6 minutes? No. 6 minutes to go through the Beat It flowchart.
Sure. So here, as Lou was saying, you're going to have a Beat It family member, parent, sibling, or a very close friend is going to contribute that $5,000. And the client is going to have a demand right over that. And that's in a lapse. And under 678A2, it's going to be a grantor trust for the client. Typically, our client in this scenario is a business owner, and he's looking to sell his business into the Beat It, and he's going to get a promissory note back in return. You could sell it directly, or like we said, you could put it into the holding company, of which the client is going to be the sole member, transfer the assets into that holding company, sell the holding company to the Beat It, get the promissory note. The client's going to take that promissory note and assign it into his trust, so that way it's not a probate asset. And now you have a mechanism where you have a business that's generating a lot of revenue owned by this trust. So it's an estate freeze because you have a promissory note at a certain value, but hopefully your client is entrepreneurial And over many years, the value of that business will continue to grow. And all the appreciation, again, is outside of the taxable estate, right? Because you have a promissory note that's locked in. The value of that business 5 years ago was $3 million. You have a $3 million note. 25 years later, it's worth $50 million. All that growth and appreciation is outside of the taxable estate. The benefit of the beat it is that because there's a sale and that the trust was formed by a third party, the client can be the beneficiary, can be an investment advisor, as well as a distribution advisor, limited to a HEM standard of health, education, maintenance, and support. So whereas in a typical SLAP plan, a spouse is creating it for the benefit of the other spouse, in this scenario, the client is going to be the primary beneficiary, could be the investment advisor, can be the distribution advisor, because they are not forming it for themselves. A third party is forming it for them. And because it's a grantor trust for that client, when they sell that asset to the trust, to the beat it, there's no gain recognized. And now the business is in the beat it and could pay, typically will be used as a mechanism to pay for life insurance policies on the client that's owned by the beat it. And now you don't have to worry about crummy powers and making sure there are crummy notices, and that all the beneficiaries and your family members are finding out that there's a trust and they could withdraw a certain amount of money. And then there's that awkward feeling at the Christmas dinner table because someone wanted to take out the contributions that were made to the trust. So the beat it is a high-powered trust vehicle where business owners could transfer their businesses to a beat it, get a note back, and maintain the ability to be a beneficiary. That's usually not done because that's a self-settled trust. When you create a trust for yourself and you're the beneficiary, that's a self-settled trust. Those assets are going to be includable in your estate. The trick here is having a third party create the trust for the business owner, having that $5,000 withdrawal power lapse, and then making the sale. And now the client can be the beneficiary, could be an investment advisor, and can even have powers to make distributions based on a limited ascertainable standard.
So we just executed one of these for a client who is a hedge fund manager, early stage career, has investments that are going to amplify over time significantly. Got the valuation, packaged them up in a limited liability company, sold the limited liability company into a beneficiary defective inheritors trust that he is the trustee and beneficiary of, so he can now manage that company just like he could if it was in his own pocket. That's his LLC, he's the manager. That money can grow, and it can grow within his beat it trust outside of his taxable estate. He has a power of appointment, so he can determine the ultimate beneficiaries of that trust and change beneficiaries at any time. And it's a grantor trust, so the income tax consequences are going to flow back to him and not be taxed at the higher trust rates that Gretchen may talk about later. So this hits a lot of the targets. It's in the IRS Green Book. That means that they don't like it, but they can't do anything about it. It's buttressed by code and statutes that allow this trust to amplify wealth going forward. And Nathan can talk to you about the power of valuation here, because when we get the discounts on hard to value assets, we crush it down with the LLC. We now have an ability to have a very small obligation in the estate because they're going to sell it in for a note. They still hold a promissory note, but the value of that promissory note is a fraction of the beat it value. And what do we do, Elwin, to pay that note off ultimately? By life insurance. You'll hear about that in a bit after the break. So the plan is a very potent plan. It's a freeze. They get a limited power of appointment. The advantages for life insurance we're going to talk about in a bit, because now, as Anthony said, you've got a business cash flowing. There are restrictions on the business buying life insurance that Elwin's going to talk about, if the follow-up from the Connolly case last year that the Supreme Court decided. But you don't have any restrictions on that purchase of life insurance. And it could be whole life, it could be variable life, it could be private placement life insurance inside the trust. So it's a great opportunity to leverage wealth, move the value down, crush the value down, amplify the value with the investments and the life insurance